Good morning. My name is David Saab. I represent the Thames Valley Chamber of Commerce, the leading voice of business on behalf of Thames Valley organisations, one of 53 accredited chambers with the British Chambers of Commerce, the largest chamber outside of London for attracting foreign direct investment. Through our recognised Centre of Excellence for Global Trade and Inward Investment, we provide services that promote and create opportunities for the Thames Valley business community. Welcome to our webinar this morning, where our speakers will be reviewing considerations for directors of financially distressed businesses and pre-pack administration. Before we start, may I introduce you to our speakers. Adam Dowdney, partner at IBB Law, and Gareth Roberts, partner at KRE Corporate Recovery. Adam is a well-known and experienced corporate and M&A lawyer in the Thames Valley. He works on all aspects of corporate law, including mergers and acquisitions, MBOs and MBIs, and private equity, venture capital transactions. Adam is respected for his constructive and commercial approach and is included in the Legal 500 Hall of Fame. Gareth has considerable experience with a wide variety of businesses in many industry sectors, with particular expertise with sporting clubs and manufacturing businesses. Gareth was previously a partner with HMT Corporate Recovery and RSM Tennant, and prior to that, a senior manager with Ernst & Young. He has 31 years experience in the corporate recovery field and qualified as a licensed insolvency practitioner in 1998. May we invite all participants to submit any questions they may have in the Q&A box, and we'll be addressing those at the end. And without further ado, I'd like to hand over to Adam.
Many thanks, David. Good morning, everyone. I hope you're all well, and thank you for joining us on this beautiful morning. So today, as David has said, we're going to have a look at the considerations to be taken into account for directors of financially distressed businesses, what they need to be thinking about, what their options may be, if the ongoing viability of their business is challenged in the current environment. And in particular, we'll be looking at pre-pack administrations, both from a seller and a buyer's perspective and an IP's perspective, the good and the bad. Delighted to be joined by Gareth Roberts from KRE, who I'm sure will add invaluable insight from an IP's perspective, not only on pre-pack and all the options, but also on the current environment generally. So moving on, having a look firstly at statutory directors' duties. Next slide, please. So there were various cases during the 20th century where the established common law fiduciary duties and a duty of care and skill on all directors was established, and these have now been enshrined in the Companies Act 2006, and there are 7 general duties which are set out on the screen. I'm going to highlight just a few of them for the purpose of thinking about the challenges that companies are actually facing during the current crisis. I'm not going to go through each of them in detail. Firstly, duty to act within powers. This is really more relevant for companies that were formed before October 2009, when the provisions of the Companies Act came in. Companies formed since that date probably have what are called general objects, but for companies formed before that time, it's possible they still have a memorandum of association, and that memorandum may have limits on the powers of the company. So you do need to check whether there are any such limits. For example, often there may be a limit on an ability to borrow money for the company. So you do need to check and ensure that the director complies with this duty, and check very carefully your company's memorandum and articles of association if your company is more than 11 years old and doesn't have what are called general objects. Looking at the director's duty to promote the success of the company, directors must act in a way which they consider in good faith would most likely promote the success of the company for the benefit of the members as a whole. And the legislation goes on to set out a list of non-exhaustive considerations to satisfy this duty, and I think they're all pretty relevant in the current circumstances. So directors have to have regard to the likely consequences of any decision in the long term. They should consider the interests of employees, which obviously has been pretty important over the last few months. They should consider the need to foster the company's business relationships with suppliers, customers, and others, again, very relevant. They need to consider the impact of the, of the company's operations on the community and the environment. It may be relevant to consider the desirability of the company maintaining a reputation for high standards of business conduct, and they must also bear in mind the need to act fairly between members of the company. So clearly, when we're looking at that duty to promote the success of the company, there are all relevant considerations to bear in mind in the current situation. In relation to exercise, the duty to exercise reasonable care, skill and diligence, a director must exercise the care, skill and diligence that will be exercised by a reasonably diligent person. Well, what does that mean? In assessing whether a director has fulfilled this duty, there is both an objective and a subjective test. The objective test is that the director must carry out his duties with the general knowledge, skill and experience that would be reasonably expected of a person carrying out those functions. That sounds fine. But there is also a subjective test, and the subjective test considers the general knowledge, skill and experience that that director actually has. So what that means is there is a minimum level of knowledge, skill and experience that is mandatory to satisfy the objective test, but there is also, where the director has a specialist knowledge, a higher subjective standard to be met. Again, very much worth bearing in mind in the current circumstances. I think it's important to point out that whilst directors also, day to day must consider all of these 7 duties in their day-to-day decision making, the courts have not held that directors are guarantors of a company's success, and clearly mere errors of judgment are not going to see them liable. Next slide, please. Looking now at how those duties may change if a company is distressed and potentially, dare I say it, heading towards an insolvent situation. I think in the currently rapidly changing circumstances, directors have to be regularly checking if the company is still solvent by either using the cash flow test, and that is whether the company is able to pay its debts as they fall due, or the balance sheet test, which is that the company has sufficient assets to meet its liabilities, which include contingent and prospective liabilities, as and when they fall due. And I think directors, if their companies are veering towards insolvency, need to be looking at that pretty much every day. And the directors have to consider when the risk to creditors not being paid becomes real, because in such a situation, the interest of the company's creditors have to be considered in priority to the normal director's duties. So there is a broad duty to maintain the assets of the company for the benefit of the creditors, which clearly creates a difficult decision analysis for the directors to take. Any period of financial distress is clearly very difficult for directors, and there is clearly going to be a challenging balance between continuing to trade, taking into account employees, customers, suppliers, premises, etc., and potentially and hopefully turning the situation around so that all creditors can be paid and the business can continue, against continuing to rack up company debt and potentially increasing debtor liabilities, weakening the position of the company, and potentially, dare I say it, exposing the directors personally. We would say it, as I'm sure KRE and Gareth would agree, but taking professional advice at an early stage is crucial and does provide significant protection for directors in deciding what path to take. I think why the position is slightly different this time to the previous recessions is the significant government intervention in a number of ways that they've made to try and alleviate trading issues for businesses through the furlough scheme, tax deferments, the availability of bank funding, changes to the insolvency rules, etc. All these measures will help, one hopes, limit the risk of personal liability for directors for the decisions that they make. However, the most important thing is that directors must still act diligently and reasonably. I think in light of this, one of the key actions is for directors to minute all decisions, to document why they have taken a certain route. A director's defence will be much more effective if contemporaneous notes can be shown of the discussions had, the decisions taken, and the advice considered. If directors feel that the company is close to insolvency, a regular update or note evidencing why they believe it is still solvent could be a valuable defence. I'm not going to go into detail about the risks of personal liability for directors, and as we know, wrongful trading has been suspended, but in fact, the misfeasance under Section 212 of the Insolvency Act was actually the more common claim and can still render the directors personally liable. I think it's important to bear in mind that the changes under the new insolvency legislation do not give directors an automatic get-out-of-jail-free card. And although they don't specifically or solely relate to the current pandemic, I think it would be a very brave director who sought to rely on the suspension of wrongful trading if his business was already in significant difficulties before the 1st of March. And to also note that misfeasance is still in force, as is fraudulent trading, and as are reviewable transactions such as preferences and transactions at an undervalue. So although the suspension of wrongful trading and the new rules will help, directors should be very careful when they are proposing to transfer any asset out of the company or pay any creditors in preference, or if there is any likelihood of insolvency, and in particular should be very careful about any payments made to connected parties such as dividends. Clearly, directors need to be very wary in these challenging times. Next slide, please. So it's clear that the role of directors in the current pandemic is increasingly challenging, as not only have they got to make some very tough decisions, they haven't been able to meet in person to discuss the issues and therefore discharge their responsibility. So just a few very quick thoughts on board meetings. I think remote board meetings have been used by many companies in the past, and certainly telephone or video attendance is not unusual. But the current pandemic clearly has placed further pressure on directors in how board meetings can be held. I think the first thing is make sure you communicate with each other, or directors communicate with each other in the best and the most secure way. We've all become very used like this to Zoom meetings or Teams, but often actually a telephone conference call is the safest and least likely means of communication to actually cause any communication issues. However, we also do all appreciate the advantage of actually seeing those we're due to be meeting. So if the company and all the directors have the right and functioning technology, then a video call can be an effective forum for a board meeting. But do check that your articles allow for online meetings. Regular contact with your fellow board members is increasingly important during this fast-moving crisis, but full board meetings might not actually always be necessary. Consider the use of committees, again, if your articles allow for it, and also consider whether written resolutions can be used to take and record necessary actions. Do bear in mind, however, the importance, and I can't overstress this, of recording all key decisions made at this time and ensuring proper and reasonable analysis of the issue has been undertaken. Any challenge by an IP or whoever further down the line is less likely to succeed if due and proper consideration of the matter was taken by the board and this is properly recorded. Indeed, any decisions made informally should be followed by a written resolution confirming the course of action. As is the case with any board meetings, ensure there is a proper, clear agenda and the meeting is run in an orderly manner so everyone knows what is being discussed and that someone is tasked to take the relevant minutes. A clear understanding of what decisions need to be made is fundamental, and sending around key relevant documents in plenty of time before the meeting will help ensure smooth and due process. Remote meetings really are no different to more formal face-to-face meetings. The agenda needs to be adhered to and all decisions noted and minuted. A recording can be used and taken to ensure an accurate record, but we would still advise that hard copies of the minutes are circulated and approved by all of the attendees. And do also bear in mind the potential security risk of sending around confidential board papers or information. If personal addresses are being used, then an electronic portal may be a suitable tool. So in summary, I think at this time for directors, do make sure you hold board meetings regularly and ensure all decisions are taken after due and careful consideration by all the directors. Keep detailed minutes of the meeting and discussions held and circulate them to all the directors. Record as much information as possible in relation to any transactions entered into or decisions made and why those decisions were made. Review the financial health of the company on a regular basis, very important. Update your forecasts, keep your cash flow under control. Keep in touch with your bank, again, I think that's key. And if in doubt, engage professionals and obtain advice as early as you can in the process to ensure and demonstrate that you have conducted your duties diligently and in the best possible manner in these very challenging times. Right, I'll now hand over to Gareth, who's going to look at some of the insolvency options for directors for businesses that are suffering financially.
Adam, thank you very much, and good morning, everyone. As Adam mentioned, we're all very well aware of the government's support, financial support through the furlough scheme, the various loan schemes, the various grants, and that has certainly helped companies survive over these past few months. But in addition to that, the government recognised that there was a need to give directors additional support through legislation, and has brought in, or is in the process of bringing in, the very nattily titled Corporate Insolvency and Governance Bill, which is likely to proceed through Parliament unopposed and should become law in early July. It's been brought in at absolute breakneck speed. Many of the provisions being discussed have been under consideration for the best part of 2 years, and earlier this year the government told our profession that it was unlikely to reach the statute books in 2020. However, with COVID coming on the scene, within 3 months the government has rushed through this legislation, and it does leave a little bit to be desired, but the focus, the clear focus of the government is to preserve companies. So we'll move on in a moment to pre-packs and the sale of a business out of administration, but that doesn't normally save the actual company itself. It leaves the company with all its debts behind, and the business is taken forward in a brand new vehicle. The government's focus is on saving the company, and its flagship provision in this new bill is a moratorium, a standalone moratorium, which gives companies a breathing space to reorganize or restructure its affairs and then come out of the moratorium intact. It is not meant to be followed by an insolvency procedure. And my initial reaction when the provisions were announced was that we'd see very few of these, perhaps only at the very high end of major restructurings of PLCs and multinationals. But in the literature that's accompanied the bill, the government or the insolvency service expects to see this moratorium used at a local level for small and medium enterprises. And it remains to be seen whether companies that are in distress can actually be saved. The moratorium is for an initial 20-day period, which can then be extended by a further 20 days, and then up to a year if the creditors or the court approve it. So you can imagine companies existing within this bubble where they can't be attacked by creditors for non-payment of debts for potentially up to a year while they sort themselves out. And big question mark, can they come out of the other end intact? What restructuring has taken place with the debts that have built up in this period for it to survive? We think that we're likely to see an upturn in company voluntary arrangements as a consequence. Company voluntary arrangements, in very simple terms, are a deal between the company and its creditors to be given a period of time, an extended period of time, possibly several years, to repay the debts that have built up out of future trading income. And the problem with company voluntary arrangements, CVAs, up to this point, is that they've been put forward often by companies that have been loss-making in the past. And creditors, quite understandably, question whether a loss-making business will suddenly magically become profit-making. The difference, I think, with the COVID intervention is that we will now be looking at companies which have been profitable in the past, but have had their income stream chopped off because of the COVID and haven't been able to trade for several months. When they start up again, they'll have confidence that they can be profit making in the future because they have been in the past, but they need time to build up profits and income to repay their old debts. And we think we'll see a lot more company voluntary arrangements where creditors are agreeable to giving companies this breathing space to generate income and contribute over a period of time to past debts. The major contradiction, as I said earlier, the government is all about the rescue of the company, the survival of the company. In the budget back in March, if anyone can remember that long ago, the government brought in the return of Crown preferential status. This is for unpaid VAT and PAYE. Back in 2003, the HMRC lost their preferential status, so they ranked equally with all the other creditors, suppliers and the like. And that meant any proceeds that could be generated from future income was shared equally amongst all the creditors, including the taxman. From December this year, the taxman will come first. So until he's been paid all the VAT and the PAYE he's owed, and you can imagine that could be quite a significant amount with the non-payment and deferral schemes that are in place with the taxman at the moment. So come December, there could be some fairly chunky tax debts have been built up. They have to be discharged in full first before any other creditor gets to see a return on their debt. So it can take a significant time for a business which is only just coming out of hibernation to generate the income needed to pay the taxman back before he can say to his other creditors, his suppliers in particular, I'm now able to start paying you back. So we think company voluntary arrangements have got a big place to play, possibly following on from a moratorium, a breathing space. But come December, big question mark if the taxman is demanding to be paid first ahead of everybody else. And because of that issue with Crown preference coming into play, we think we'll see a lot more administrations and the sale of a business and the assets of the company out of the administration, leaving the shell company with all its liabilities behind, and then the creditors will only get a return based on what the assets were sold for. But again, if it's after December, those proceeds of sale will go to the taxman first. So I think the poor old unsecured creditor is likely to see a lot less return on his debt. So I think it's all very well the government talking about the rescue of the company, but there's a contradiction with the taxman suddenly becoming at the head of the queue. And as a consequence, I think we'll see a lot more administration sale of businesses through pre-packs, which is the focus of the rest of this presentation. I put liquidation on there just to cover all the options. It's obviously the least favourable. In simple terms, last man out, turns the lights off and locks the door behind him and the auctioneers move in. So we're not dwelling on that today. That's just to cover all the options. If we could move on to the next slide, please, Joe. So the pre-pack sale, there's been a lot of discussion in the past about abuse of this process. There's a lot of talk of shady deals where the management was sold the business back for £1. No one else was given a chance. Creditors are up in arms because clearly if you've only got £1 for the business, there's not going to be any return for the general body of creditors. And that led to government intervention a couple of years ago, about 2016, with what was called the Graham Report, where some professor from a university in the Midlands somewhere, I think it was, put together a report which led to the creation of something called Statement of Insolvency Practice 16, SIP 16. So if you're either a business owner thinking my business might need to go through administration, or you're listening as a potential buyer, because I think there'll be huge opportunities to acquire businesses over the next few months and years, it's worth downloading SIP 16 off the government website and having a read of it, because it's the protocol that I, as an insolvency practitioner, have to follow on a daily basis. And if you can understand the protocol, it puts you in a good position to understand the process that'll be followed, whether you're the owner going through a fairly distressing time or you're a potential buyer looking at an opportunity to acquire. In very simple terms, the key message from SIP 16 is the need for an insolvency practitioner to market the business widely. You can't go down the pub and flog it back to the management for £1 anymore. I am doubtful, by the way, whether that ever happened in reality, but anecdotally, many creditors will tell you that's what happened. But the key impact for us of SIP 16 as an insolvency profession is we have to market the business as widely as we can, looking for the best price. The realities can be slightly different. If there are key personnel in a business who are telling us it doesn't matter who you find as a potential buyer, we're not going to go and work for them, it can kill any potential deals. Good example recently we had is a software company where there was a key developer in the business, and he said, I'm only going to continue to work for the management team. So if they don't buy it, I'm off. So every third party competitor who came along who liked the product that we were developing was put off immediately, because as soon as they went and spoke to the key developer who said, well, I'm not coming to work for you, I'm out the door, if you buy it, it killed all that interest. And it led to only one potential buyer, which was the management team. So we do look closely at SIP 16 with the marketing responsibilities, but we also look behind that and identify, are there key people and what's their agenda? Because until we understand that, there's often sometimes no point trying to find a third party buyer if no one's prepared to go and work for that third party. And that brings us on to the management conflict. If management wants to buy it back, as Adam mentioned earlier, remember their duty, the management's duty is to the creditors to maximize the recoveries and result in the best return possible for creditors. But if they want to buy their business back at an absolute knockdown price and will do all they can to put off anybody else who might be interested, it does give them a conflict. And again, as Adam mentioned, it is important they take the right advice and manage that conflict. It's not easy to manage, but they have to be very careful that they don't get criticized if their conduct is such that it is obvious to one and all that all they wanted to do was thwart any third party acquirers to ensure that they get their business back. And that's where creditors often get quite upset. And it's important that the directors, the management team take the right advice. If they've simply had enough and all they want to do is maximize the recovery for creditors and try and keep their employees in a job with a new owner, then SIP 16 is fantastic and we're all aligned. If there's a conflict because they want to buy it back, then it's important that they take the right advice at an early stage. And again, hopefully that's where we can assist. Next slide, please, Joe. This really applies, well, to both the directors of a company, but in particular a potential acquirer. You get to hear that a business is on the verge of administration or a pre-pack sale is being contemplated. The business will be marketed, it'll be advertised on various websites. Deal Opportunities is a particularly good one that you can register on, and you'll get notification of potential distressed sales. So you come along and express interest in the business, and it's important that the chances are the insolvency practitioner has only become involved possibly a week or two before you get notice of the opportunity to acquire the business. So he hasn't got all the answers. He's very reliant on the management team, and I come back to the conflict there. If the management team don't really want it sold to anybody else, we would hope that the management teams would accept their responsibilities to try and do the best deal possible. Doesn't prevent them bidding in competition, but we get very uncomfortable and sometimes decline to act if a management team makes it clear that they're not going to engage with SIP 16 and deal with interest from third parties. Sometimes we just have to say, sorry, this isn't for us. You'll have to go and find somebody else who's prepared to act on that basis. Most management teams, even if they're interested in acquiring it, will engage with potential buyers. But it's important the potential buyers understand that we don't necessarily have all the answers. We are dependent on the management team for information, and we all have to work together on that basis. We'll always get a valuation of the assets of a company, the physical assets. That's very much to give us a base level that if we can't find a buyer and we have to sell on a breakup basis, that's our bottom line benchmark. And what we're looking to do is improve upon that. But potential buyers often ask us to see our valuation. It's not for potential buyers, it's to give us a benchmark of what our bottom line potential sale price is. Buyers can always go and get their own valuation. If it's an engineering company with some heavy kit, then it's perhaps worth doing. If it's a software company, then you can't put a value on that. It's what you're prepared to pay for it. So often people get very wrapped up in the importance of valuations. Not always that important. It's what are you prepared to pay for the business. That's what's key. And SIP 16 is the transparency. So understand what we as insolvency practitioners are trying to achieve through SIP 16. And if you understand that as a potential buyer, then we can work in tandem. But it will move quickly. Normal marketing period is 2-3 weeks, perhaps. Usually the company's running out of cash, might not be able to meet payroll at month end. So there's not months to market it. There's not months to carry out your due diligence. And Adam will come on and talk about due diligence in a moment. But be prepared that you will have to move quickly within a couple of weeks often to get your head around, are you prepared to take an element of risk in making an offer and proceeding with the acquisition? And again, you're going to be very reliant on the key players. So if I can give you one tip, and hopefully I'm not crossing over one of Adam's tips, understand very early on who are the key players within the business and get your arms around them and understand their agenda, and are they aligned with you? Because you're going to be quite reliant on what they have to say about the business. You're not going to be able to do weeks and months of due diligence. And a little final plea before I hand back to Adam. We are genuinely, as an insolvency profession, trying to act in the best interests of creditors. And in simple terms, that is usually trying to get the best price we can to maximize the return to creditors. But we have to work with the management team. And if sometimes they have their own agenda, we can be thwarted in maximizing the recoveries. And sometimes it's a case of selling it for what we can. It might at least protect jobs. It might give suppliers a new customer with which to trade. It might give customers continuity of services. So there can be upsides from a sale of a pre-pack, even if the price isn't the greatest. And part of SIP 16 is us being able to explain to creditors that we did our best in often very difficult circumstances. So that's a bit about what we as insolvency practitioners are seeking to achieve and how we go about it. And I think it's Adam now to talk about a bit more of the detail if you're thinking of acquiring a business out of a pre-pack.
That's great. Thanks a lot, Gareth. That's really helpful summary. So as Gareth said, slightly flipping on his head, and if you're potentially interested in buying a business by way of a pre-pack, what are the advantages, but equally some of the perils? I mean, I think it is inevitable, as Gareth said, that many businesses will be going into administration or some form of insolvency process, I'm afraid, when we come out of this period, when the furlough periods come to an end. Some of the money has to be paid back, etc. And I think that could present a great opportunity for businesses that are financially strong, that have come through this process, have come through this crisis with a strong balance sheet, when some of the competitors may not have. And there will be opportunities without doubt to consolidate in your sector, possibly to diversify, to give you greater balance sheet stability, to expand your offering, to maybe buy further down the supply chain, etc. So there will be opportunities, because buying a business by way of pre-pack, it is going to be a lot cheaper than buying it if it was a fully functioning, financially viable, up and running business. So there will be opportunities without doubt, and you could get a cracking deal. I mean, as Gareth has said, you can structure a deal pretty much as you want to do it. Most of the liabilities to creditors, as Gareth has said, will stay with the seller, subject to the deal you negotiate, obviously. But that does mean you can cherry pick to an extent, take the assets, the good bits that you want to acquire, and leave behind some of the liabilities for Gareth to deal with. So you can get a cracking deal, and you can you can make sure you get just the assets that you want. You can take simply the assets, or as Gareth says, you can take the entire business. That does have implications both for tax and for employees, but it does mean you can look at the business, understand it, and work out which particular assets are key to you. There may be other bidders, but in some ways that can work. Sometimes they may want to acquire different assets. You can get into a sort of a bidding war. Gareth and the IPs are always quite careful around trying to maximise value. So, you know, do understand if there are other bidders, and if it is a management team, that does put a slightly different play on the process, as Gareth has alluded to. I think for some, the speed of the acquisition actually is attractive. There isn't any messing around. You sometimes see very complex acquisitions turn around in a few days. We've acted on 2 or 3 recently in this period where we've acted for clients buying or looking to buy out of administration, and things do move very quickly. Gareth and I worked on one over an Easter weekend. So, you know, they do move very quickly. What that does mean is it's pretty high intensity at the time, but your management don't spend weeks, months, or even longer tied up in complex commercial negotiations, hammering out the finer points. It's really commerciality and pragmatism are the main deal drivers at this stage. Employees cuts both ways. If you acquire the business as a whole, lock, stock and barrel, you're probably going to get the employees under the 2P regulations. And what that means, it gives you a ready-made workforce at a fraction of the cost of recruiting them from scratch. I think what Gareth said is absolutely key, is understand those employees, understand what value they bring, etc. But it can be a real asset to the business. However, for all the advantages, there are, I'm afraid, some pitfalls. Joe, if we could have the next slide, please. As we said, the process will move very quickly. If the assets are being sold via a pre-pack, the deal needs to be agreed before the administrators are officially appointed, and they will be looking for a buyer as soon as possible. As Gareth has said, they will advertise, they have to advertise the business for sale, so you may not be the only game in town. And therefore, you need to be very focused on coming up with a deal that is flexible and focused and structures a deal that works for you and the administrators. Bear in mind what Gareth has said, they've got to maximise the creditors, maximise the value that they can for the creditors. That's their driving force. So the usual comfort of the deal process of really getting under the skin of the business, understanding how it works, negotiating every single warranty, etc., as we love to do, that's not going to be happening if you're buying out of through a pre-pack. And that does mean clearly you're taking more of the risk, so the price you offer should reflect the more of the risk you're taking. Information gathering, again, Gareth has alluded to this, there's not going to be much by way of due diligence. Do make sure you understand the key assets you're buying and focus your due diligence on those key assets. What is important, I think Gareth again has alluded to this, is that if you are a third-party buyer and there is a management team who are also interested, you are entitled and you should be getting the same access to the same information. So make sure you do get that. If possible, ask to speak to the employees directly. Again, Gareth mentioned that. I think that's absolutely key. Understand who those key employees are, what their function is. And it's not just speaking to the management, it is speaking to the employees, and clearly speak to the administrators. Equally though, do remember, as Gareth said, that the administrators have probably only been in the business for a couple of weeks. They don't know it that well. They're not, you know, they won't have a huge amount of extra information than you. So make sure when you ask questions to the administrators, those questions are focused. Try and do it all at one time. Don't do it piecemeal, and try and make sure those questions are properly focused. Do understand why the business failed. Was it simply over leveraged at the wrong time, or is there something more sinister that's happened to put it out of business? So it's really important to understand the business. I think something that's really important if you're buying some key assets is go and look around the business. I appreciate that's not been so easy during lockdown, but I think a physical inspection of what you're buying can be really important. And equally understand what third-party consents are required. That can be a real stumbling block, particularly if you're trying to move quickly. So really some information gathering is going to be quick, it's going to be limited, but make sure you're focused on what information you're trying to get. Employees, we've talked about, it's a real key area of risk for an unwary buyer. If you are acquiring the business is effective as a going concern, you are going to get the employees lock, stock and barrel by provisions of 2P. Do bear in mind that some may be on furlough, so the immediate picture of the employees may actually not be complete when you get it. But the employee contracts, if 2P does apply, will transfer. You can't contract out of it. And if 2P does apply, then there are certain informing and consulting obligations which arise, which you don't want to get wrong, because that could lead to substantial liabilities and compensation claims. And Gareth will agree with me, the administrators aren't going to be on the hook for those. They will be seeking indemnities from you to pick up any such liabilities for any 2P costs, and they can be extensive. So you really do need to get the 2P bits, the employee and the 2P bits right, and get good advice around that. You won't be getting any warranties or indemnities. The administrator is the agent of the company and won't accept any personal liability in the sale contract. In fact, quite the reverse. They'll be looking for indemnities from you. There'll be no warranties about the assets sold, whether they're encumbered, their ownership, their condition, etc. So again, it does mean some sort of physical inspection is important. Ask the right questions, but there won't be any ability to go back after the deal and try and get money back because it wasn't quite what you thought you were buying. Do consider whether some element of deferred consideration is appropriate, as this can sometimes be agreed with administrators if they want to sell the bulk of the assets to one buyer rather than piecemeal here and there. But I think for IPs, very much because they're trying to realise that the most they can for the assets, cash is king. So the more upfront for an IP, the better. But also be aware there aren't going to be any price adjustment mechanisms. There's not going to be an earn-out, or there's not going to be completion accounts or anything like that. So be very comfortable with the price you're paying. Encumbrances, check that any appropriate releases have been obtained from existing funders. Absolutely key, because they may have debentures or charges over the assets you're acquiring. And also check the terms of the administrator's appointment to make sure they have the relevant authorities to sell the assets. And a last few points to think about: premises. I think in the short term, at least, the business probably is going to need to operate from somewhere, and that is likely to be as existing premises. It might be that the assets are fixed there, or a lot of the stock is there, or whatever it may be. So it's really, really important to check and understand the existing arrangements with regard to the premises, because you may need to conduct pretty rapid negotiations with the landlord to ensure continuity if you do want to stay in the premises. You're very unlikely to get an assignment of the lease or a new lease agreed in the timescales that we're talking here, and therefore you're likely to need to get the administrators to grant you a license to occupy. But even then, if the lease has been breached, which is quite likely, the landlord may not allow the lease to continue, even if the rent is being paid, even though actually under the current legislation there's little the landlord can do to enforce payment of rent. But the premises is a really complex area. If you do need them for the operation of the business, get under the skin of how the premises are going to operate going forward. Make sure you speak to the landlord, get the administrators on side, and make sure you've taken it into consideration as early as you can in the process. Book debts, are you going to buy them? If you are, make sure you know that if they're being assigned to you, that they're probably not all going to be collected. So make sure the price you pay for the book debts reflects this. Equally, if they stay with the administrators, remember they need to collect them, and they need to collect them in order to pay off the creditors. So their collection might be quite aggressive, and they could be upsetting your potential customers that you've acquired as part of the business. So just something to be aware of around book debts. Contracts, I'm not going to go into the new rules in the insolvency legislation around how contracts work, whether they can be terminated on insolvency, etc. I think it's created some interesting situations there. But you do need to understand, if there are certain key contracts, understand their assignability, even if in theory they can't be terminated. Because if a contract needs to be novated, you can't compel a third party to novate or enter into novation for the contract to be transferred across to you. And do remember, stock could be subject to retention of title provisions, and valid claims could reduce the value of the stock substantially, clearly therefore creating a cash flow issue for you, because the suppliers will want to be paid in full. So understanding the contracts, retention of title, absolutely key. Intellectual property as well, check who owns it, does it properly belong to the company, are the IP licenses up to date and transferable? Know what you're buying and that you are protected around those key assets. And also, I would add, it sounds obvious, but check it works, preferably prior to purchase. It's not uncommon for administrators to be instructed to sell companies who have spent years developing the product, and regularly the failure of the app to work or the high-tech piece of kit to operate properly, that's actually the cause rather than the result of the underlying issues that brought the company down. So make sure you understand what you're buying and that it does actually work. And finally, again, pretty obvious, make sure you prepare all your forecasting carefully. Make sure you understand fully how much working capital will be required to operate the business, etc., going forward. And do consider putting the assets you're acquiring into a new co, so they're ring fenced in case there are any significant issues. It means it shouldn't impact your core business, and it can be dealt with separately. So I do think it's sensible to set up a new co to acquire the assets in case there are issues post completion. And most importantly, go into this process with your eyes open. There will be some bargains out there, but do be prepared to walk away if the deal doesn't look quite right. Right, I'll hand back to David now, and then I think we're going to have a Q&A.
Excellent. Thank you so much, chaps. May I compliment you for the clarity in which you delivered your content today. I actually understood it, which is sometimes the legal jargon and stuff, right? It was very clear, 616. So thank you so much. This is going to be so valuable for our members. First question, Gareth, could I just ask you to repeat the name of the business for sale website that you mentioned?
Yeah, there's a couple that insolvency practitioners tend to use. My favourite is Deal Opportunities. I think it's dealopportunities.co.uk. You can simply register as a participant, and they will send you regular e-shots of distressed opportunities. There's a second website that some insolvency practitioners use. We've had less success with this one, but again, no harm in registering. It's called IP, I for insolvency, P for practitioner, ipbid.com. So Deal Opportunities and IPBid are the two traditional websites that insolvency practitioners advertise distressed businesses for sale on.
Nice one. That's perfect, Gareth. Thank you. And another question, is warranty and indemnity insurance generally available in distressed sales?
Not come across it, Adam. I don't know if you're
No, it's a very interesting question. I've been speaking to an insurance provider that we use for general M&A warranty insurance, and we did ask them specifically whether a 2P risk could be insured. His response initially was, no, I think that's unlikely, and this wasn't in the sort of situation, but actually it is something I think they are looking at. How high the premiums might be might make it prohibitive, but as Gareth has said, it's not usual. It's not something that's normally looked at, both because of the risk and also because of the speed. I mean, clearly they do take time to understand process, etc. But look, I wouldn't say it's a complete no, and as I say, I've had some discussions with an insurance provider we use suggesting that it may be something that can be looked at, both around the warranties and indemnities and also around 2P.
I would certainly highly recommend, I think it was Adam's final point, if you are acquiring a business, put it in a standalone vehicle, possibly as a subsidiary company of your main trading business. Because if you do find after a few months you've bought something you didn't think you were buying, and to be frank, it's a bit of a dog, it's much easier then to let that go, as opposed to incorporating it into your main trading business, which could give you difficulty. So I think the best protection is buy it through a standalone new co-vehicle, just in case it isn't quite what you thought it was.
Okay, excellent. And another question, do the panelists expect to see a surge in corporate failures? And if so, when is this likely to be?
Crikey. That's a great question, whoever put it forward. I'd like to say don't know. I don't think there's many economists out there who are absolutely certain. A lot will depend on how quickly we come out of the recession. There's been so much government support over the last few months that businesses have been able to hibernate quite effectively. And I think the acid test will be, as markets reopen, do companies have cash with which to start trading again, to buy stock in, to buy raw materials in? to meet wages when the furlough scheme starts to drop off. So I don't think there's going to be any immediate wave of corporate failures other than maybe some big ticket retailers. But generally, I don't think there's going to be a huge immediate wave. I think the big test will come in the autumn when, in particular, the furlough scheme starts to drop off. Landlords can start pursuing rent more aggressively. The taxman can start pursuing unpaid tax more aggressively. And have companies got the cash reserves with which to meet those liabilities, or do they need protection from their creditors by one of the various rescue mechanisms we've talked about today? But what I would say is, and I go back to the early 90s when I started out in my career, and there's a big recession then. If there are failures, conversely, it provides big opportunities for the companies that are strong to either step into the shoes and fill the gap left by a business that fails and leaves the marketplace, or to acquire the business and assets of those failing businesses. So yes, I think in the autumn there'll be an upturn in failures, but with it will come an upturn in significant opportunities as well for the stronger businesses.
Yeah, makes sense. Thank you so much. Another question we've received. I appreciate a pre-pack acquisition happens very quickly, but are there any particular key areas I should look at?
Yeah, it does happen very quickly. You know, as I've said, you're not going to get the full due diligence, you know, questionnaire going out with 100-odd questions and lovely replies coming back telling you where everything is. So there are certain key things to look at, I think. One is around encumbrances. You know, check the charges register to make sure the assets aren't charged and you are getting what you're getting unencumbered. I think one that you know, check the administrators are properly appointed, because they need to be able to sell the assets that you're acquiring. Gareth has talked about setting the structure up in a new company, so you can, if things do go wrong, you can wind that up. I think the key really is understand what the key assets are and get some real comfort around that. So if you're buying a particular piece of kit, go and look at it, make sure you understand how it works, make sure the serial numbers are on it. It's stuff like that. I think it is difficult to you know, every business is going to be different as to what the key asset or the key item you're looking at is. So I think you know, the basics are check the administrators are properly appointed, check they're not charged, set up your new code, that sort of stuff, and then it's really a case of focusing on what the key assets are and getting as much comfort as you can around them, and clearly the employees, sorry, that we've talked about around 2P, understanding that, because you get that wrong, that can be very expensive.
Sure. Excellent. Thank you, Adam. Another question. How do I pitch my offer for the business in a pre-pack, and how inventive should I be?
Maybe I'll have a go first.
Let me just start. As an insolvency practitioner, I'm a very simple human being. I like simplicity. So make the offer as straightforward as you can. There is nothing worse than an offer opening with, we are prepared to pay X for the assets, and then there's 3 pages of conditions attached to the back of the offer. Try and clarify in your short due diligence period and knock off as many of those conditions as you can, because if we get a straightforward unconditional offer, it is often more attractive to us than a higher offer which has got 3 pages of conditions attached, because we will question, will we ever get that deal done in the time we have available, usually before the company runs out of cash and has to cease trading, will we ever get through those 3 pages of conditions? So keep it straightforward. You don't need to be creative or inventive. List the assets you want to buy. It's quite right, you say you want to make sure that we are able to sell what you want to buy, and that comes back to Adam's point about encumbrances, and do the assets actually, are they owned by the company in the first place to be able to be sold on? So clarifying ownership is fine, but if you then go and say, and we want to do consultation with the employees for 30 days because we're worried about the 2P risk, it's just unattractive to an insolvency practitioner. And our job is to do the best we can for creditors, and sometimes that is taking a lesser deal that we think we can get over the line in the time available than hoping to get a much higher price, but actually it will never happen. And we're pretty good at sniffing out the speculative bids. If someone makes an offer that's too good to be true to try and entice us in to engage with them exclusively, the offer probably is too good to be true. We'll have a good nose for what a business is worth very quickly. And if someone offers spectacularly more, we're a bit suspicious. So keep it simple, keep it straightforward, try and remove as many conditions as you can. And that's what will be attractive to an insolvency practitioner.
Excellent.
Yeah, and from experience on the side, I completely agree with that. I mean, Gareth, interested to hear your views. I think deferred elements of consideration will be looked at, but actually a deal which has more upfront is going to be more attractive than one that is delayed payments, etc., because that's clearly not going to be attractive to the IPs. I think it's also the case, Gareth, that you probably rather sell more to one person than bits here and there, just because it's easier. So try and structure a deal that works in that way. I mean, I think it's been interesting. Some of the experiences we've had when we've been putting offers together is I think try and make your best offer up front and be comfortable with what you're offering. Don't expect lots of negotiation. So come up with your best and final as early as you can in the process and be comfortable that that's what you're paying. As Gareth has said, IPs don't like being messed around with an offer that's way over the top, and then you start trying to chip away at that. That's not helpful. So it's the main ethos. You know, it sounds trite, but cash is king, and the more upfront you can do, the better, and make sure you're comfortable with that offer.
Yeah, great steer, chaps. Appreciate that. This is one for you, Gareth. More your expertise. Do you think the new moratorium process will be popular and well used?
When it was first outlined by the government, I didn't think it would apply because most of the businesses that we get involved with, the company with all its debts and liability is unlikely to survive. And that's why pre-pack administrations are so popular, because you can leave the bulk of the liabilities behind, save for the landlord perhaps, if you're taking the premises and the employees under TUPE, but you can leave everything else behind. The government is very focused on the company surviving with all its debts and liabilities intact. So initially, I didn't think it would be that popular because a bit of protection from creditors for a limited period isn't a magic wand. All the moratorium does is give you a breathing space. You've still got to sort all the problems the company has out in a fairly limited time. So I thought it would only be seen in the big restructurings. But the government is convinced, and it's in all their handouts, that this will be widely used. I'm just wondering what magic can be brought to bear. If you've got a company in financial distress, has been making losses, what does an initial 20-day, possibly extended to and by another 20 days, so effectively 2 months, what magic can be brought to bear in that fairly limited time scale? It is extendable if the creditors and the court agree, but if a company has fundamental problems, a short breathing space isn't going to solve those problems. So I'm skeptical. I think it'll lead to more company voluntary arrangements, which are extended periods to repay your creditors over a long period of time, but caution about the taxman jumping up the top of the queue. And I think we'll see lots and lots of administrations and pre-pack sales, and I think they'll still be the main focus for rescue, albeit it'll be a sale of the business and assets, leaving the company and its debts behind. I don't think the moratorium will solve the problems companies have.
Interesting. 20 days certainly isn't a magic period, is it? Okay, another question, chaps. I know that DD may be limited in a pre-pack situation, but what should I focus on in particular?
I'll give one, and then Adam can chip in with others. The one I would focus on day one is employees. Understand their agenda. Are they aligned to you, or are they going to be difficult? If you're buying an engineering company and they've got 100 blokes on the shop floor, it's maybe not quite so important. The chances are they'll just want to come into work, whoever employs them, and earn their wage and then go home. I'm talking about the businesses where you've got key personnel who drive the business. So it could be software developers, it could be people in the sales team who've got the key client relationships, which if they moved on, they might take those clients with them. So identify the key employees, get your arms around those employees and understand, are they aligned to your intentions, and then take a view on whether there's still a business worth acquiring. And the converse to that, I suppose, would be if you're thinking, I'll buy the business, but I don't really want any of the employees and I'll leave all them behind, Chupi's probably going to intervene and prevent that happening. So understand the Chupi implications. If you want all the staff and they want to come with you, fantastic. But if they don't want to come with you, or you don't want them, then that needs bottoming them out on day one, because Chupi is very rigid and does frustrate business sales, where either the employees don't want to go with the new owner, potential new owner, or the potential new owner doesn't want the employees. So key understanding for me is employees. Adam?
I completely agree with that. I mean, the irony is Chupi's meant to protect employees, but actually in this sort of situation, as Gareth has said, it can be an actual block to getting a deal done. And it is, as I've said, you know, it's a key area of potential risk. And I completely agree with Gareth. That's one of the first things to take a look at. I remember one of the first purchase I did out of administration, I was given access to the data room and I got all excited. I went in there and there was so little information in there. You are not going to get lots and lots of information. There's normally something around the premises, there's something around the employees. You might be lucky and get something around some of the key contracts and sort of an asset register. And that's, you're not going to get a lot more than that. I mean, Gareth, there might be more, I appreciate. But I think it really goes back to what I was saying is understand the assets you want to acquire and ask the questions around them. Don't waste the IP's time asking questions that aren't really relevant. Really focus on what's key and make sure that you understand how that works. And I think a key question to ask Gareth, and I think this might be quite a good way to end, because I don't know if you'll answer it, is if I'm coming in as a third party in a pre-pack, can I ask you, are the management team interested? Because if they are, that to me is a potential, you know, that's a really important consideration as to whether I think I've got a good chance of acquiring the assets, or if I'm up against a management team who potentially, let's say, have a have a personal guarantee in the business. You know, they are already on the front foot and are more likely to get a deal done than me.
It's an absolutely valid question. I'd probably prefer not to be asked it by a buyer, but I think that it's a great question to ask either of the IP or direct to the management team when you're introduced to them. Because if they are intent on buying it, as I mentioned in one of my earlier slides, it does bring potential difficulties to the whole process. So understanding that on day one is important. Equally, they might want to buy it back, but they might be a bit strapped for cash with which to acquire the business and then trade. And it's often the case that somebody coming along could partner up with them. So rather than acquire it and take it away from them, you actually get into bed with them, so to speak. So yeah, understand the management's position is very important.
Excellent. We have time for one final question. Do you have any thoughts on how secured lenders, e.g. banks, are likely to respond to a pre-pack for one of its customers?
I think it depends on who the customer is. If it's a third party acquiring a business, then the third party's bank will be supportive and will look at the funding of that. And they're very used to dealing with potential acquisitions from administration and providing the working capital support. It's a bit more difficult if it's the management team who've got a debt with a bank, or the company's got a debt with a bank, and what they're saying to the bank is, we'd like to roll that debt over. We can't afford to repay it, but we'd like to roll it over into the new company. And banks are very publicity conscious of being seen to support a pre-pack, and are concerned about being seen to support a pre-pack which looks after them, so to speak, because their debt is taken over into the new vehicle, but everyone else, the poor old suppliers, for example, are left behind. So you will find certain banks saying, we will not support a pre-pack, we will not roll our debt into a new company. So if you're the management team, you need to understand from your bank, if you want to put a bid together to acquire the business, will your bank be supportive, or will they say, no, you're on your own, you need to find a new lender to support you going forward? I think if you're a third party going to your bank saying, I've got my eyes on this company, I think it's a good opportunity, then normal lending criteria apply, and banks are pretty good actually at, from what we've seen, of supporting their customers acquiring businesses.
Excellent. Adam, anything you'd like to add?
No, I agree with all of that. You know, the banks that, you know, that we've come across acting for a third party going in are pretty quick, understand the process, understand and need to move pretty quickly. So yeah, no, I'd agree with that.
Okay, excellent. Thank you so much. I found this fascinating. To conclude, on behalf of the Chamber, thank you, attendees, for coming on this journey with us during the webinar. I'm sure you'll join with me in thanking Adam and Gareth for sharing their expertise and insights. I'll be circulating a copy of today's presentation, if that's all right with you, Adam and Gareth.
Yeah.
And both Adam and Gareth welcome any further questions that you may have regarding to today's topic or any other insolvency or legal matter. In closing, you'll agree we're currently facing unprecedented challenges, which is why the Thames Valley Chamber of Commerce, alongside our partners in the British Chambers of Commerce, would like to draw your attention to our business continuity toolkit, aimed at ensuring we have a single portal to access all of the COVID-related support. You'll see the website in front of you. As I say, that'll be in today's presentation, which we'll circulate today. Once again, thank you for joining with us, and this concludes our webinar for today. Thank you.